Welcome back to the Law and Crime Network, everybody. That was a short pretrial hearing right there in the Thomas Robinson case out of Arizona. What we do know is that a new day was set for February 16th. The trial date was set for March 1st. That has been delayed, though. And so we are going to wait to hear what happens in that case, a really interesting case about this municipal court judge who was arrested for domestic violence, allegedly stabbing his wife 10 times. And apparently he and his wife first tried to cover it up. They tried to allegedly remove the knife, different evidence of the crime. They said an intruder did it. Well, that didn't last long. The wife recanted, called the police, and said that her husband was the one who stabbed her. But then she turned her story around again and said to the court, this was a completely out of the ordinary action. I trust my husband. I love my husband. I miss my husband. Well, it's definitely an interesting case to follow. We're going to have to see what happens. But as you know, we are covering the Quinton Tellis case here today. We've been playing replays of it all day. We started yesterday as well. And the reason we're replaying this entire case is because that case ended in a mistrial, and we anticipate in 2018 that Quinton Tellis will be retried. So we're trying to understand what happened. Why was the jury split? And we know that 7 of the 12 jury members voted to convict Quinton Tellis. So here to help me understand a little bit about what happened and what we can expect, I'm joined by attorney Jonna Spilbor. Jonna, great to see you here in 2018.
Always good to see you. Happy New Year.
Happy New Year. So I had Ron Blitzer here earlier today. We talked about what I felt was the biggest reason why the people were not able to convict Mr. Tellis, that it was the Eric or Derek statement that was uttered by that was allegedly uttered by Jessica Chambers of what the first responders heard. And you kept hearing first responder after first responder, hearing what sounded like an Eric or Derek. Do you believe that was the biggest piece for the people that voted not guilty here?
So what's really sticking in my craw about this is when I was here when that trial was live.
Great expression, by the way. Just know that.
You're welcome. I was not, that piece of evidence did not sway me in favor of an acquittal at all. In fact, you know, not that I can put myself in the shoes of somebody who's on fire, who's been burned over 90% of her body, but I think anything that she would have uttered at that time, instead of being a, quote, dying declaration, is something absolutely unreliable because of her physical state. So even if she said Derek, Eric, if she said Jesse, why was she saying it? In other words, we can't determine that she was trying to identify the person who set her on fire and killed her. Maybe she was calling out to a loved one. Maybe she was delirious. We don't know what was happening because she was burned over 90% of her body.
So the people that look at her statements and say, well, she was able to utter her name, she was able to utter who she was, she was able to say that she was cold, she was obviously coherent in that way. How would you respond to those critics of saying, well, if she was able to utter those names, she was able to utter those statements, then why couldn't she say Quinton? Why couldn't she say Tellis?
Well, I would argue that you just can't put any reliability on that. Saying her name and saying that she was cold has nothing to do with convicting another person. So in a case like this where you have such a gruesome crime, I understand the importance of getting it right, but there was so much other evidence that was reliable that favored a guilty verdict. And in fact, 5 of the jurors would agree with that, or 7 of the jurors would agree with that, that I just don't think you can hang your hat on that one piece of evidence that she said maybe somebody else's name when she was dying.
Now, every jury's different, right? So if they retry this case, what is the prosecution going to do moving forward? Do they change their strategy to say, hey, listen, we got 7 people to want to convict this guy. We can convince a full jury of 12. Or what do they need to do to change their tactics moving forward?
Well, first, I think it's a little bit unusual in a case where you have such, look, it's almost a 50-50 split, right? So the prosecution does have a bit of an uphill battle, as opposed to one single holdout, which would be a little bit easier for the prosecution to go ahead and retry. So the prosecution will be silly if they don't re-examine everything and figure out how to change their strategy to get, if you're going to take the time and expense to retry this gruesome murder case, then you have to examine what you did wrong, because if you didn't get a conviction, you did do something wrong.
Do you think John Champion, who's the prosecutor, got a little wish-washy with the facts? I mean, he says, I submit to you that she was strangled, that she was attacked by Quinton Tellis, and that he ran from that car, left her in the car. I'm going to read you exactly what his timeline was. He borrowed his sister's car, got his gas can, drove to the scene, poured gas in Chambers' car, lit it on fire, then drove to Batesville, Mississippi to purchase the green dot cash card he was planning to send to his girlfriend in Louisiana. This back and forth, I wonder if that was a little bit too wish-washy for some jurors.
When you say wish-washy, remember this. You probably weren't born yet, but Scott Peterson 10 years ago, what was it, 10 years ago when he was tried for the death of his wife, Lacey
I appreciate
Peterson?
that, by the way. I moisturize.
So young and debonair. But that case, there was precious little evidence as to how Lacey actually died because she was in a body of water for 4 months. She washed up, no head, no hands. It was impossible to determine the actual manner or cause of death, I should say. So for a prosecution to get wishy-washy with the facts in a case like this, on the one hand, shouldn't matter all that much because we got a conviction in a death penalty case against Scott Peterson when there was zero evidence as to how she actually died.
Yeah. I think that John Champion made a great point when he said, I don't think it's feasible for Chambers to leave Tellis's company and then within 4 minutes got together with somebody else who killed her. I mean, if you look at the timeline, he was with her. Tellis was with her. He said he had sex with her, and when you look at the car, the way the car was set up, the passenger seat was in the reclining position, which is exactly what happened in his story. For him to be with her, and then all of a sudden a third party comes in, that is probably what the people that voted to convict him said, I don't buy it.
I would agree with that because it's just not plausible. And you have to remember, jurors are instructed that they can infer facts from what's been presented to them at the trial, right? They can't make things up out of whole cloth, but you're allowed to make an inference because sometimes you need to do that. So if there's a 4-minute gap in time between, the last physical contact with the defendant and then her dying, it's not a big leap to say, well, who else could it have been? That's the one thing that I think jurors probably ask themselves more than anything else. If not him, then who? And when you don't present evidence of a third-party culpability, because they didn't, the jurors are allowed to say it doesn't make sense for anybody else to be the culprit here.
Did you have any issue with the fact that ruling other people out, these third parties, and we say the investigators, we're going to probably see it later today when we play the testimony, that they said, we looked at every avenue. We got rid of everybody that we didn't think was a suspect. We looked at all the Erics and Derricks. We looked at all the characters in the neighborhood.
Right.
And they were only able to, their prime suspect was Quinton Tellis. Did you have any issue with what did that mean to really rule other suspects out, particularly when a name Eric or Derrick was apparently uttered?
I think that information is important to a jury because of what I just said. They want to know, if not him, then who? And so if it came out that they did actually investigate other Erics, Derricks, other potential culprits, that's important information for a jury because remember, oftentimes a defense attorney is going to point out just the opposite, right? They're going to point their finger at the prosecution and say, you only looked at my client. You didn't look anywhere else, which is equally important for a jury. So I think in this case, I would love I guess nobody did this. They should talk to the people who voted not guilty and find out precisely why.
Is that something you could do if you're retrying a case? Are you actually permitted to do that?
You're allowed to talk to the jurors after, unless the jurors don't want to talk to you. And you're allowed to, because it's not going to be the same jury on the retrial, obviously. It's going to be a brand new jury. And if they want to talk, they can, but they don't have to talk to you. Now,
do attorneys do mock trials in a way? Maybe they did a mock trial before this, and they try to understand what are the pieces of evidence that maybe are the weakest. I mean, here they have a great, like you said, they have jurors that actually listen to this whole case, impartial jurors, and they, like you said, they might be able to interview them and said, what were you not convinced about?
Where did we go wrong?
But where did we go wrong? But in terms of trials in general, do you usually see maybe a mock trial beforehand and say, okay, this is our strongest argument, these are our weakest arguments, and you take impartial people to listen to this?
So, all right, between me and you, I don't think prosecutors ever do mock trial. I really don't, because at the time you get to the point of trial, you've had the case for a very long time. You've poured over a ton of evidence. You usually think that you have a solid conviction ahead of you. And so for that reason, and maybe for budgetary reasons, because we'd be paying for that mock trial as taxpayers.
Absolutely.
It's not common for the prosecution to do that. Will they do it now in between today and the next trial? Might not be a bad idea if they really want to get a conviction.
And this is a huge case. I mean, this was a huge case, not just in 2017, but in that whole community. And I say it'll be difficult to find jurors that didn't hear about this case or weren't influenced about it, because this really, I think, due to the fact that the heinous nature of it and the different factors that were involved in this case, I mean, it took the country and that community by storm. So there's a lot riding on them to get that conviction.
And also consider this. Put yourself in the defendant's shoes. You just walked out of a courtroom not convicted of anything, right? You weren't acquitted, but you were not convicted. Now, trying to get a plea bargain might be a bit harder for the prosecution because the defendant here is going to have a little bit more confidence. Well, I rolled the dice once and I sort of won. Might as well roll the dice again. So it's not, you know, are they going to come back to the table and say, we'll charge you with voluntary manslaughter instead of, you know, murder? And will you take that and be out in 15 years? I don't know.
You talk about a plea bargain. I'm so glad you talked about this because Ron Blitzer made it a good point earlier. I said, if they retry him, there's obviously a big split here when we talk to anybody and our viewers and guests, split about whether Quinton Tellis was guilty or not. If they retry him and there's a mistrial, will they try him again for a third time? And he says, I wouldn't be surprised if they then try to make a plea deal. What would you imagine? If there's a mistrial when they retry him again, what would happen?
If they miss the second bite of this apple, the plea deal would probably be to something ridiculous like even involuntary, not even manslaughter, maybe assault, something that would have him out of prison, but at least put a felony on his rap sheet. And even then, if I'm representing him and prosecution loses twice, I might not advise my client to take that plea deal unless it's to jaywalking. Then all right, but nothing more severe than that.
Well, I hope they do have some more updates and information in this case, and there is a retrial, because we'd love to have your opinion about this when we do get a second bite at that
And
apple.
I still think he's guilty, but all right.
See, you're on one side. There's people who think he's guilty, there's people who think he's innocent, and you can see our message boards for what people, how they're split as well. Again, we are replaying clips from this case. I want to continue our coverage of that today. I'll be signing off. Amy Dash will be signing on, so thank you for joining me this morning. And we do have a day filled with more special segments, including not just Quinton Tellis, but we're going to be, on the network, we're going to be covering the sports betting case out of New Jersey, a situation with singer Erykah Badu being pulled over by police officers to just say hi. We're going to be talking about Yvonne Cordes. We're also going to be live streaming the Brevard County Bond Court. And then we're going to talk about the legalization of marijuana in California. Big day here on the Law&Crime Network. You're not going to want to miss anything. But in the meantime, here is a clip from the Quinton Tellis case.